How do we know that
we're now live?
Are we? Where do you see that?
So welcome everybody. I think we're live. We're very new to this platform. So if anybody's in the public room and can just message us on public chat to say that you can hear us, that would be wonderful. And then I will briefly introduce our speakers.
Oh.
Michael, thank you very much.
Michael.
Very kind. So I'm Emily Jones. I'm an associate professor at the Blavatnik School of Government in the University of Oxford, and it's a great pleasure of mine to moderate today's panel. We have a fabulous lineup of speakers. We're going to go first with Elisa. I didn't even ask you, Elisa, how you pronounce your surname, but Baroncini?
Baroncini is perfect.
Baroncini. Lovely to have you with us. You're a full professor of international law at the University of Bologna, and you're going to be talking to us about the EU treaty scrutiny processes. We'll then go to Holger Hestermeyer, who's Professor of International and EU Law at King's College London, who's going to talk to us about the UK's treaty scrutiny processes in the new post-Brexit world order that the UK is in. And then we'll turn to Gabriel Gari, who's a reader in international economic law at the Queen Mary University of London. He will talk to us about stakeholder participation in the United States, which we're very much looking forward to as well. We've asked all of our speakers to make short, incisive presentations of just 8 minutes to start off with, to make the key points. And then we hope that will mean there's a lot of moments for questions and answers and discussion, and the chance for them to elaborate their key points in more depth. So perhaps without further ado, Elisa, may I turn to you? And please, as you're listening to this, do put comments in the chat. We'd love to hear your thoughts as we go along, and please do put questions in the Q&A column, and we'll be drawing on them when we open up for Q&A. But Elisa, the floor is yours, please.
Thank you so much, dear Emily, and let me take 30 seconds to deeply thank you, Professor Gabriel Gari, for having put together this panel, and Professor Holger Hestermeyer for having involved me in this very interesting perspective of researching on trade policy, and also Professor Emily Jones for having accepted to chair our panel with her great knowledge and experience. So my topic concerns the role of the European Parliament in the shaping of EU trade policy and agreements of international economic law, and I will divide it in 2 parts. So first, as an introduction, I will briefly speak about the new powers for the European Parliament that are provided for by the Lisbon Treaty, both with reference to the shaping of instruments of trade policy and for the conclusion of international agreements, also dealing with the fight that was undertaken by the European Parliament for the full respect of its new institutional prerogatives. And then the second part will be devoted to the great contribution of the European Parliament to the shaping of principles and the tools of international economic law. So the great contribution that the EU is giving to the debate of the substantive principle and the institutional principle for the governance of the global economy. So the Lisbon Treaty. The Lisbon Treaty is very important because it extended the role of the European Parliament as a legislator for the development of all the EU policies, and in particular of the EU trade policy. And also it is very important because it adopted a provision, Article 218 of the Treaty on the Functioning of the European Union, concerning the decision-making procedure for concluding international agreements. Everything is inspired from the institutional point of view by the principle of representative democracy that is contained in the Treaty of the European Union, Article 10, and by the substantive principle that have to guide the international action of the European Union that are enshrined in Article 3, paragraph 5 and Article 21 of the Treaty on the European Union. And basically, the international action of the European Union has to be guided by the principle of sustainable development, the principle of free and fair trade, and the principle of promoting constantly multilateral solutions to common problems. These guiding principles have always also to characterize the trade policy of the European Union, and within the trade policy of the European Union, the European Parliament is a leading actor, because nowadays is a co-legislator together with the Council of the EU, and with reference to the conclusion of international agreements, the European Parliament has to give its positive assent to the new generation of a free trade and investment agreement of the EU, because of Article 218, paragraph 6, that says that the consent of the European Parliament is needed also for the agreements covering fields for which at internal level it is observed the legislative procedure. It is applied the legislative procedure. The strategy of the European Parliament to fully perform these new institutional prerogatives are divided into 4 aspects. The European Parliament did not hesitate to reject proposed agreements if it was not properly consulted, or the final content of the proposed international agreement did not fulfill the expectation and the political choices of the European Assembly. Then the Parliament performed a very high political pressure in order to have full transparency in the treaty-making negotiation, in the treaty-making procedures of the European Union. And then the Parliament started to adopt resolutions on the external policies and the future agreements of the European Union, indicating the substantive and institutional aspects of the future agreements that it wanted to be respected in the final version of the treaties, and so these strongly influenced the negotiators of the European Union in their activity. And when the situation was very difficult, the European Parliament did not hesitate to file complaints before the Court of Justice of the European Union to see the full respect of the institutional prerogatives guaranteed by the jurisdictional pillar of the European legal system. And I will quote one very important case concerning the duty to fully and immediately inform the European Parliament, that is a prerogative guaranteed by paragraph 10 of Article 218 of the Treaty on the Functioning of the European Union. The this duty to be, this right to be fully and immediately informed has been protected by the Court of Justice in a case that was ruled in 2014 that concerned an agreement on the fight against piracy, an agreement with the Republic of Mauritius. And in that case, the Court of Justice said that since the Parliament was not informed about this agreement until 2 weeks after the publication of the agreement by the Council on the official journal, it said that the right of scrutiny of the European Parliament had been violated, and it said that the requirement of transparency of Article 218 had to be considered as an essential procedural requirement, as an expression of the democratic principle to which the European Union is founded, and through which the people, through the European Parliament, may participate in the exercise of power in the shaping of trade policy. So this right of scrutiny and the right to be fully and immediately informed for any kind of international agreement concluded by the European Union is fully considered by the Court of Justice, and also fully performed and implemented by the European Parliament. And in fact, in a framework agreement of 2010, reached between the European Parliament and the European Commission. The European Parliament was given a full participation since the very beginning of the treaty making procedure. So even when nowadays, when the Commission presents the mandate, proposes a mandate, recommends a mandate for opening international negotiations, these recommendations are addressed at the same time at the Parliament and the Council, and the Council reached the very strong achievement of having the Council waiting to develop the guidelines, the directives for the negotiations, to wait until a resolution on that future agreement is adopted, even if it is not binding by the European Parliament. And in fact, the principle of transparency is one of the major achievements that has been reached through the pressure of the European Parliament. Nowadays, we can say that the European Union is the most transparent negotiator in the world. So each step is very transparent, and then the attention of the European Parliament shifted from transparency to the main elements of international investment policy of the EU. And so it was a thanks to the European Parliament that the multilateral investment court system and the transparent evolution of dispute settlement concerning investment was promoted, that the right to regulate is fully considered in the new generation of agreements by the European Union. And also all the very articulated and innovative chapters in the new generation of free trade agreement concerning sustainable development, they have been promoted by the European Parliament. If we read the wording concerning the resolutions on the agreement with Vietnam, we discover all this full attention by the European Parliament that looks for mandatory rules concerning the promotion and the full application of core labor standards by the partner of the European Union, and also that the enforcement of these sustainable development chapters must be very strong and very effective. Beyond the presence of the European Parliament, the shaping of international agreements on international economic law, there is a strong attention by the Parliament on unilateral measures. I will just mention the carbon border adjustment measure, but also the full attention of unilateral measures with reference to the relations with China. In May of this year, the European Parliament adopted a resolution blocking the ratification process of the cooperation agreement on investment with China. And it underlined, it stressed the importance to adopt unilateral measures to ensure that the supply chains with China fully respect human rights and environmental protection. And in fact, the European Parliament is proposing the adoption of a unilateral measure, so a regulation on due diligence, so of responsibility of economic operators dealing within or with the the EU market. And also the European Parliament is strongly promoting a regulation concerning instruments to be adopted by the European Union, concerning measures to be adopted by the EU against economic coercion.
Thanks.
My last remark
please.
will be on soft law, because the Parliament did a lot of work and significantly contributed to the debate of the new instruments for international economic law and international economic governance. But what is a point on which it has to work, in my view, and it is about how to deal with soft law instruments. Because, for instance, the European Parliament said, I will freeze the ratification process on the cooperation agreement on investment, but the bilateral relations between the EU and China are currently governed by informal instruments that are managed by the European Commission with the Chinese government. So there is the problem of who controls all these soft law instruments through which we can circumvent the very important democratic prerogatives established by the Lisbon Treaty. And in my view, a possible way out, a possible solution would be to set up a mechanism of mandatory notification of any international instruments concerning, for instance, a trade policy to the European Parliament, so that there will be the members of the European Parliament who will scrutiny, who will check, who will control what is mandatory and what is not mandatory, what is politically relevant and what is politically less relevant, in order to guarantee the full respect of the institutional equilibrium established by the Lisbon Treaty, and also the full participation of citizens, stakeholders, civil society, through the presence and through the action of the European Parliament, where it is guaranteed by EU primary law. Thank you so much for your attention.
No, thanks, Elisa. And you've really pointed out there the sort of activist role, if you like, of the European Parliament. I was quite struck by the European Parliament when it feels that its rights are being infringed upon. There it is taking a court case forward, right? So a very activist, so quite a powerful, but also quite an activist legislative branch when it comes to treaty making. I know in a little while, Gabriel is going to talk about stakeholder participation in the United States. And I just wondered if you had any reflection on, within the EU mechanisms, the role of external stakeholders and consultation, and how that works and its strengths and weaknesses.
Within the EU debate, the role of stakeholder is highly, highly considered and is becoming stronger and stronger. You have the European Parliament that lobbies quite significantly to give more space to the debate and the voice of stakeholders. And also you have the European Commission that uses its competence and its activity in order to enhance the participation of civil society to the shaping of the trade policy. The transparent approach to international negotiations is a clear sign of this, and also the launch of public consultation for the major aspects concerning trade policy instruments, both unilateral measures and international agreements, is there. There is a platform where every one of us can introduce its consideration and thoughts for the future policy, future instrument of trade policy of the EU. And recently it has been set up by the European Commission, a Chief Trade Enforcement Officer, which is a high official of the European Commission, having the role to collect all the complaints concerning multilateral obligations and bilateral obligations of trade and investment treaties involving the European Union from the stakeholders. So it's very simple. You go online, you put your indications, and the European Commission will manage these. And this Chief Trade and Enforcement Officer constantly speaks with the European Parliament, also with in-camera discussion, in order to update on every single aspect of trade policy the members of the European Parliament. So
so again, it sounds like a very sort of transparent participatory system. We're going to have to move to Holger, who's going to reflect on the UK, but I wonder if in the Q&A part we might come back to any sort of questions on the weaknesses of the European system. So you've pointed there sort of the EU at the forefront of kind of an accountable, transparent, fully open, consultative process. And perhaps one question for you when we come back to the discussion, are there any weaknesses in the EU setup? And if you're listening and if you're in our audience, please do keep putting your comments in the chat. We're monitoring them and any questions that you have. But Holger, please, let's turn to you and the UK. And what does the UK system look like? We were, of course, sitting in the UK as I am, we were part of the EU system. That was our default until a couple of years ago. Please, you've got 8 minutes to just tell us where we're at. Oh, I think you're muted.
Makes my presentation so much better when I'm muted. Thanks a lot, Emily. Thanks a lot to everyone. And it's really good to be at SIEL, even though I can't see all of my friends. Anyways, the UK system, of course, now that we're out of the EU, we have the chance to make everything better. But before we start making everything better, let's take a step back and say, why is parliamentary involvement even essential in free trade agreements? Free trade agreements, of course, have moved from being just about tariffs, or mostly about tariffs, to being a lot about regulation. And regulation, to be legitimate, needs parliamentary input. We are sort of at the cutting edge of globalization. How can we make sure that we can still effectively govern globally and make global rules, while at the same time ensuring those rules are legitimate at the parliamentary level? And I'll discuss the UK system for obvious reasons, because I work in the UK, but also because it is really a new and developing system, which is unusual for a system that has been around for hundreds of years. So I will try to discuss three issues. I will set out the problem. Why is it a new system, really? I will then discuss more in the abstract, what should Parliament's role be, which is a constitutional law debate, if you want. And then I will turn to three specific problems, and you will see that basically this is just a large roundabout way to reach the same point that Elisa has reached. So let's start with the problem. Brexit happened, and there were 1,261 treaties in the EU treaty database, and the UK would lose access to many of them. The Financial Times did a count in 2017 and said 759 treaties need to be replicated. The UK government then went through them one by one and decided that 157 treaties needed to be saved. And clearly the UK processes were put under an enormous amount of pressure. What are those processes that the UK had for negotiating and making treaties before Brexit happened? First of all, and quite peculiarly after the EU experience, negotiating, signing, and ratifying treaties is all part of the so-called royal prerogative, which now means their executive powers. This is really the realm of the executive. Parliament basically was reduced to two entry points. One, known as the Ponsonby Rule, in 2010 was put into a statute called the Constitutional Reform and Governance Act, CRAG. When we speak about CRAG, that's what we speak about, in 2010. And the involvement of Parliament there is that treaties need to be laid before Parliament, 21 sitting days before they can be ratified. And then either house can resolve against ratification, so the Commons or the Lords. If the Lords do it, they can only do it once, and then the government can decide, we'll just ignore you. The government can decide the same with the Commons, but then the Commons could theoretically repeat this process and have another delay of 21 days. The reality of this process, because of the reality of the political system of the UK, in which the government controls Parliament's timetable to the largest extent, is that actually not much scrutiny had been going on. There was no organized committee really in charge of this. Since 2014, the House of Lords, peculiarly, Secondary Legislation Scrutiny Committee at least looked at 69 treaties, but none had been drawn to special attention of the House. That was the first process. As you can see, not terribly effective in terms of parliamentary involvement. The second process is that because of a long-standing constitutional convention, the Foreign Office puts the implementing legislation to Parliament before ratification of the treaty. And so if the implementing legislation is voted down, the treaty dies with it. That was the large chunk of how the UK made treaties. Then there was an additional chunk for how the UK was involved in EU treaty making, because there the process was stronger. First of all, because of the stronger European processes that actually require a parliamentary consent vote on a lot of treaties, unlike the UK. And then secondly, because most EU agreements are mixed agreements, so you'd have involvement in the EU processes plus the UK processes on top. And in the EU processes, there actually was a dedicated parliamentary committee. In fact, one in the Commons, one in the Lords, that scrutinized the agreements. But much like CRAG, those arrangements could be waived by the government, stating just reasons. And so interestingly, when CETA, the EU free trade agreement with Canada came to the UK Parliament, the government decided not to go through the scrutiny processes. There wasn't a debate, and that really offended quite a lot of MPs who thought this was EU policy. But when you look, of course, at the history of CETA, even the Parliament of the Walloons could manage to have an impact on CETA and block the whole process. The UK Parliament wasn't allowed to do that because the government decided to sidestep it. Now, all of this falls away in the EU process, and we are stuck merely with the UK processes, which leads us to a question. How can we improve those UK processes? The first step clearly was, because of the mass of treaties going through UK Parliament, there needed to be a more organized process. So the correct scrutiny under the correct procedure finally was done in an organized manner, peculiarly not in the Commons, though, that has the power to delay several times, but in the Lords EU Committee took charge in January 2019 of organizing treaty scrutiny. And then in April 2020, a subcommittee of the Lords EU Committee, the EU International Agreement Subcommittee, took charge of scrutiny. And that subcommittee now has become a full committee with the end of the transition period and with the exit from the European Union. Why is treaty scrutiny organized the way it is in the UK? The idea, of course, is Parliament needs to have a hold on legislation. But a lot of people in the UK think, well, because it's a dualist system, that is really sufficient. If you can vote on the implementing legislation, you don't need to vote on the treaty because we're dualist. Treaty doesn't matter. Of course, that misconceives both what dualism really does and also what other countries do, because there is the misconception that most continental jurisdictions are dualist. The reality is most continental European jurisdictions are monists, sorry. In reality, they are mostly dualists. And so they too require implementing legislation. The problem is, if you only vote on the implementing legislation, you might be forced by the treaty to do something that you never voted on. Who decides what is sufficient to implement the treaty? If that is the government, well, the government can take bits out of the implementing legislation that should be part of the scrutiny processes before you agree to a treaty. And so this vote on the implementing legislation is insufficient, and the crack vote really doesn't do a whole lot. But here comes an interesting problem of the constitutional setup that limits UK treaty scrutiny. In the US, in France, you have the parliament, you have the president, the executive, with enormous external powers, and parliament that in an almost adversarial processes checks what the president can do. And indeed, that was how US Congress finally got its procedures for fast track of treaties in place. It basically set a deadline to the president and said, look, you have the power to negotiate, but we get a vote on legislation. We will basically force you to abide by the procedure that we lay down in a statute. Germany is somewhat less adversarial, but you still have a government that's, even though it comes from parliament, is not entirely identical because of proportionate voting, a multitude of parties, and less effective control. The UK system is a two-party system, first past the post. The executive is the majority in parliament, and that has an enormous effect on how treaty scrutiny works, because you won't have adversarial procedures, because the majority that is the government will not tell the government you're misbehaving. And that redefines how we need to perceive treaty scrutiny in the UK system. It's not a system of adversarial control. It's a system of improvement. Parliament has the most effect if it makes clear to the government that they are the contact point to constituencies, and this is what constituencies want. And this leads us to the final point of my presentation. 3 quick issues why Parliament at the moment has a hard time fulfilling this mandate of mitigating between the government and the constituencies. The first one is time and timing. Parliament gets 21 sitting days for scrutinizing trade agreement. Parliament only gets to look at those agreements after they have been signed. So there's no impact of the constituencies because they don't see anything. They don't know how the negotiations have been proceeding, and they don't have impact in that regard. There's a commitment now to at least publish the objectives. But in those 21 days, you cannot even effectively understand an agreement. You read a detailed provision in an FTA, and you need to know what's the impact on industry. You will call industry, and industry will say, well, we're busy right now. We can come in 3 weeks. And you say, well, that's too late. By that time, we won't need your help anymore. So timing is an important issue. Good news today, the Trade Committee has achieved a political commitment that the government will leave 3 months between publication and actually laying the treaty to Parliament. Second problem, amendments and decisions of treaty bodies. And if you want a rather radical example of that, it's the UK-Switzerland free trade agreement, where an agreement is developed by treaty bodies. It is unclear what happens in terms of scrutiny. And that is something that the government can effectively use. And here comes the agreement of UK-Switzerland, which in theory provides continuity for, I don't remember, 8 or 9 Swiss EU agreements that are basically carbon copied into the agreement. That's Article 1. Article 2 then says one of those agreements actually doesn't apply, which makes you wonder what this is all about. Article 3, and I might get the numbering wrong, Article 3 then says, well, the joint committee of this trade agreement can provide that this agreement will now apply. How do you scrutinize that? Do you scrutinize it at the beginning, even though it's not in force? That sounds counterintuitive. You should scrutinize the decision of the joint committee, but there's no provision for that in CREG. So amendments and decisions. And then the final one, and this is where we go full circle and are back at Elisa's presentation, what you do to agreements where you're not quite sure what the legal format is. CREG applies to treaties subject to ratification. Where a treaty is not subject to ratification, or where you're not entirely sure it even is a treaty, CREG does not apply. UN Security Council resolutions, for example, sorry to drift outside of trade, are not subject to scrutiny under CREG. And of course, if you don't sign a treaty, but an MOU, well, no scrutiny there because there's a large consensus that MOUs, after all, are not legally binding. But when you see an MOU with a dispute resolution procedure, you start to wonder what exactly non-binding is supposed to mean. So we have a lot of work to do with regard to treaty scrutiny. It continues to be relevant, and there are so many difficult questions, and we're going to have a lot of fun trying to resolve them.
Thank you very much, Holger. And if you've got comments and thoughts, please do keep putting them into the chat and raising any questions that you have. And that's a nice, I think, segue to the United States. I know there's been talk about, with the expiry of TPA, we've also got executive orders that the president can pursue there. So this whole question about sort of when is a treaty and when is it an MOU, the sort of soft law and scrutiny of non-treaty international agreements is a really interesting area for us to explore. But we're going to turn actually to the question of stakeholder engagement and pick up that thread. And Gabriel, I know you've been looking extensively at the role of stakeholders and the consultative processes in the United States, which has been a very heavy lift to try and get insight into that. So we're very much looking forward to your thoughts and reflections and analysis, particularly on the US-UK agreement, I think.
Yes, thank you, Emily. Thank you, my co-panelists, and all of us who are joining us today, and for the conference organizers to putting together this event in such a difficult time. Yeah, I think what the topic of this panel is the domestic institutional framework of trade policy making. And Holger and Elisa were looking at the allocation of competence as between the executive and the legislative. But another important piece of the jigsaw is stakeholder engagement in trade policy making. So that's what I'm going to look at by focusing on one case study, which is the United States Trade Representative consultation on the UK US-UK trade negotiations. Just a sample to look at to use it as a springboard for looking at the broader picture. This is part of our working process, which I'm very interested in, is looking at the quality of the domestic institutional framework for underpinning trade policy making and the trade and investment commitments that come at the end of this. Depending on how well is this designed, what is the consistency of the commitments across agreements, what's the political support that you can garner for those agreements, etc. So that's something I'm pretty much looking, I'm fascinated at. So two things. First, I'm going to make the case of why at this time stakeholder engagement on trade policy making is more important than ever, and then present the empirical findings of this consultation. So why should we bother with stakeholder engagement, which is pretty expensive, cumbersome, takes time? I think 4 main reasons. First of all is the expansion of the trade policy agenda. Long are the days, or gone are the days, where we were talking about tariffs and quotas. You know, the panoply of policy areas covered by trade agreement, we all know, go all over investment services and many societal concerns. So what is at stake, the range of stakeholders that are affected has expanded significantly. So we definitely need to involve more people who we need their say, their input on something that they will be affected by. Second issue is that the difficulties in getting political support for trade agreements. You know, Holger was talking about the example of the Bologna parliament, making difficulties to ratify the CETA agreement. We know that Trump's trade policy overtaking NAFTA and calling for the renegotiation of so many others. And so there is a need to get people on board when we engage in these issues. And when we look at state practice, this clearly has been a reaction in the UK, in the US, Canada, Australia, of taking steps to make effective engagement of stakeholders, creating advisory committees, implementing public consultations. In my paper, I cite many examples of documents where there are, public commitments to say, yes, we want to make trade policy inclusive. The new USTR talking about we need to give voice to the voiceless in trade policy making. So my point is, my inquiry is, how do you do that, and how do you do that effectively? Now, there are different ways of engaging stakeholders in trade policy making. I'm looking at one specific, which is public consultations, but it's not the only one, and there are others. So, the legal framework of stakeholder consultation in the US on trade policy making is quite detailed, quite formal. I cannot go on the details, but there are express mandates of Congress to USTR to develop guidelines for consultation with companies, with the public, and even the USTR, the last trade policy authority, make express mandates to the USTR to engage small businesses in the trade policy making process. So it's a quite formal thing. Now, is this working? Is this efficacy? What's the efficacy of this? Now, this is a difficult question to try to answer empirically. So I looked at 2 different dimensions that can give us an idea of the efficacy of public consultations. One is outreach, so who actually responds to public consultations, and the other is impact. What does the USTR do with stakeholders' input in the formulation of the trade negotiating objectives? Now, I may fall into the risk of getting into the details of the data, and I want to avoid that. So anyone who is interested, I have my PowerPoints online on the seminar website that you can do that. But let me outline the main findings in terms of outreach. So who responded to the consultation? Everything is online. The number is quite modest, 125 respondents, the majority of which are business associations and large firms. So we have an underrepresentation of civil society, individuals, and others. What did the respondents asked for? So this was a heavy lifting empirical work of classifying policy requests along 34 categories that then we aggregated into 10. And the vast majority of the requests were on trading goods, almost 44% of these policy requests. And well beyond that, we have 11% on trading services, 7% on digital trade, and then others. Then, to what extent are the respondents and their requests representative of the range of stakeholders and their needs likely to be affected by the US-UK trade agreement? Now, this is very difficult to ask. So I used a couple of objective proxies to answer to this. One thing is comparing the number of respondents with other responses conducted by the USTR, which numbers dwindling within 100, 150. I also compare responses with consultations undertaken in foreign jurisdictions, in Australia, in the EU, in the UK, apart from the UK one, which is quite, it reached over 6,000 people, with individual responses in this UK-US negotiation. In EU and Australia, it revolves around 100. Then I compared, the sector of activity of the respondents with the structure of the US output. There's a clear overrepresentation of the agricultural sector, with 16% of respondents, whereas it only accounts for 1% of the US economic output. The same and underrepresentation of services. Then I looked at the content of the policy requests with the actual content of the trade between the US and UK, which is roughly 50% trading goods, 50 trading services, but there's clearly much more interest on trade in goods. So clearly there's plenty of room for improving representativeness in this sense. So giving more chances for responding to consultation, holding public hearings outside Washington, not just in Washington, and other suggestions that I have in the paper. Let me pass on to the other aspect of the efficacy of this consultation, which is impact. And here is, what weight did the USTR assign to the policy requests in the formulation of the negotiating objectives? And in particular, how did the USTR balance conflicting stakeholders' demands? Now, these are more difficult to assess because there's not much information out there. The USTR, the only thing that publicly does is it makes the consultation, the responses are online, and then it publishes a summary of negotiating objectives. But we don't know what was the weight of different demands and in phrasing these objectives. So again, I had to rely on proxies to this. First of all, I looked at the framework of the stages for the negotiations and the timing of the consultation. Funnily, the consultation is made after the US has already notified Congress of its intention to negotiate. So this is already telling us that to some extent the dice has been cast before the consultation. Then the period of consultation, etc. But then I contrasted, let me put it this way, because I'm running out of time. I focused on three issues that were particularly conflicting: demands on rules of origin, demands on the liability framework for internet service providers, and demands relating to investor-state dispute settlement. Here we could find in their requests clearly opposing objectives. So what is the national interest that the trade negotiators have to champion in the negotiating table in light of these conflicting demands? How did they do it? So I look at that. I look at the broader context, the Trump's policy agenda. What were the provisions on these issues included in agreements already concluded? What were the negotiating objectives for other trade negotiation process with the EU, with Japan, with Kenya? And, roughly speaking, all these elements taken together can tell us that there is the agenda has been pretty much decided before the consultation. We don't want ISDS because it's a policy insurance for companies to set up the factories in Mexico. We want to high regional value content for rules of origin because we want to ensure that no one free rides on the benefits of the trade agreement, and we pump up manufacturing jobs, so on and so forth. So all these things gives some idea that the dice have been cast. Now, that does not mean that the USTR does not engage on consulting stakeholders. It just says that this particular mechanism, there are other ways of engaging through Parliament, where Congress people tell them what are the concerns of the constituents, through trade advisory committees, and there's a black hole of informal consultation that we don't know how does it work. But what I say is that there's definitely room for introducing some clarity on this consultation and how conflicting demands are managed, and so on and so forth. Now, looking forward, I definitely need to expand the empirical basis of my research to make more conclusive findings and find a stronger, methodological and theoretical framework for the analysis. So this is an open call to anyone who is interested in this issue, who would like to join with me in pushing research on this area. That is, I'm more than welcome to hear from others. Yeah.
Brilliant. Thank you very much, Gabriel. And I think then what comes across so strongly is this idea that we've got all this input coming in, but it's quite biased in the sense of it's heavily weighted to the agricultural sector, but also, as you rightly question there, I think reveal very nicely the question that doesn't necessarily translate into impacting on what's happening in the negotiating room, which I guess to me opens up the question perhaps for all of us, it's just what is the role of government and how does one arrive at what is in the national interest, if you like. So government's getting inputs from lots of different stakeholders, they're often conflicting. Who makes the judgment call as to what the national interest is? And sort of from a philosophical normative point of view, who should? Right, so there's a kind of the positive question of what's happening in practice, and then there's the normative question of what would an accountable system look like. I'm opening up the floor now, please, for questions and answers or questions from the audience. So please do use the Q&A bar. I'm sure all of the panel members have got lots of questions for each other, having heard that. I know in my role as moderator, I would love to table a whole lot of questions, but we'll give priority to anyone from the floor. I can see, Idonna, you've put a comment in the chat bar, which I think was off Elisa's presentation. And Idonna's there asking, when looking at unpacking EU policy positions, due to concerns raised by specific member states, what transparency is there for understanding the decision-making process? So I guess the EU Council in sort of how EU member states' positions are then reconciled. I don't know if you looked at that, Elisa, in your work at all.
Yes. May I answer?
Please do.
Okay, if you take the resolutions of the European Parliament concerning the project for a transatlantic trade and investment partnership between the European Union and the United States, this resolution is very important for many aspects, and with reference to transparency in international economic law, the European Parliament asks the member states of the EU to promote debate, to promote participation of civil society and stakeholders in the shaping of the content of the future EU-United States agreement. So this is one aspect. So you have the European Parliament asking for transparency to the member states. And the other aspect is that since it is so unpredictable, the result of the ratification process before the parliaments of the member states of the European Union, as has been underlined by Holger in particular, the institutional solution that has been promoted in recent years after also the opinion of the Court of Justice of the European Union for the Singapore Agreement, the 215 opinion, is to promote at EU level EU-only agreements. So, for instance, if you take the Brexit agreement, the trade and cooperation agreement between the EU and the United Kingdom, that was reached just only between the EU on one side and the United Kingdom on the other side. Why is it so? Because we want to avoid surprises before the national parliament. And so let's say that the democratic process is entirely on the shoulder of the European Parliament, who was very articulated in assessing, evaluating the project, and also in saying, okay, I agree from the provisional application to the full definitive application of the TCA. And it said, inter alia, for instance, that civil society should have a greater saying in the monitoring process of this international agreement, the TCA, so the involvement of civil societies in the common bodies and in the institutionalized monitoring process during the implementation of this agreement. Okay, so
Elisa, if I understand you well, then it's really thinking about then the European Parliament being a mechanism for civil society from all different member states to sort of have input. I guess, if just building on Idona's question there, and please, Idona, do come in either in the chat or in the Q&A to build on your point or to come live with us. But I guess the question I have as well is, if, for example, you're a French citizen and you want to understand what the French government is advocating vis-a-vis a specific trade agreement, for example, EU-US negotiations, how much transparency is there about the EU member states' formal position as opposed to sort of French stakeholders, if you like, pushing through the European Parliament? How transparent is that process from a sort of citizen accountability point of view?
Who has to answer, me?
Yeah, I was asking you.
Okay. Well, let's say that is an indirect process of promotion of transparency. Because of this, I mean, because of the great role that the European Parliament can perform on international trade agreements of the European Union, Brussels nowadays is very strong with NGOs, with lobbying entities that know that the European Parliament can shape, can be relevant in the definition of the future EU trade policy instruments, be they unilateral or treaty instruments. And there is an indirect process of promotion of transparency. Let's say that it is strongly advocated this bottom-up approach. So, for instance, the Commission, even before presenting the proposal to the Parliament and the Council for a new EU measure, launches a public consultations in order to gather the different opinions from civil society, from stakeholders, and they pay a lot of attention to this bottom-up approach. Why? Because, for instance, nowadays the agreement between the EU and Canada is enforced, but on a provisional basis, because the full ratification process before the assemblies of the member states is not still achieved. And so in order to avoid this, the greater participation is promoted since step one, so since the first conception of any new instrument. So let's say that member states have to be transparent because they cannot avoid to do this due to the presence of the EU.
Things going wrong.
To the presence, to the presence of the EU. So if I would have to advise an enterprise or an NGO that is worried on environmental protection, on the full respect of human rights, on the trade relations between the EU, so the member states, and China or Latin America, I would advise to contact the members of the European Parliament. In particular, there is a key committee within the European Parliament, which is the Committee on International Trade, the INTA committee, who promotes debates, reports, involvement of stakeholders and civil society who are of the greatest interest. So let's say that all the involved audience should have the clear perception and the knowledge of these institutional prerogatives of the European Parliament, which have a lot of meaning for the shaping of this highly relevant EU policy, which is trade policy.
So that's a good segue, I think, to the question I wanted to put to Holger and Gabriel, which is this question. I think everyone's mentioned it. There's a lot at stake here, right? So trade agreements have now become so expansive. They're no longer the kind of tariffs and quotas of the 1970s. They affect a vast array of economic policy areas. At the same time, as I think it was Holger mentioned, the devil isn't really in the detail. These are incredibly complex legal documents that run to certainly hundreds of pages and sometimes thousands of pages. So we're thinking there about Gabriel, you're focusing on stakeholders giving input. Holger, you've been thinking about the legislative branch, but in reality, an MP picking up several thousand pages of a legal text, or even a small business, right, or civil society, how actually do we make sure in practice that either of those branches are able to do their job of scrutiny and holding to account, or indeed understanding what the implications are likely to be, and therefore, from a business perspective, being able to give input? So just the thoughts of the practicalities, if you like, of just making this system work. I'd be really interested to hear your thoughts. So perhaps, Holger, on that question of just the MPs in the legislative branch, the practicalities of that accountability.
Yes, absolutely. So I think I also wanted to refer to your question before, the end point. What are we trying to achieve, and what's the role of these stakeholder engagements? I think one of the things, because I've been wondering about that myself, one of the things I would favor is trying to emulate in external relations the decision-making procedure for internal relations, because as soon as they differ, you create incentives that shouldn't be in the system. Like, for example, the executive going out trying to bind the country to an agreement because that is a way in which they can achieve a goal that they could never get through Parliament. And on the role of MPs, the role of small businesses, the role of engagement, there definitely is an educational issue here. Of course, we're all academics, so we probably see educational issues everywhere. But it's really difficult to understand these agreements, and it is unrealistic to assume that MPs who get voted into Parliament in the best of days because of their expertise in one area, worst of days because you'd really like to have a pint of beer with them, will then be able to understand the details of a highly complex agreement. So we need to put in place advisory procedures. There need to be paid advisors who are neutral, who will be able to walk them through these issues and explain them. And this is not any different in reality to domestic policy making. Quite often in proportional systems, you can say, well, it's sufficient if the various parties, each have their experts. Of course, in first past the post, that would mean you just have 2 experts. That's not sustainable. But there you can work with committee experts who will walk members through the details. But this will require an enormous amount of time. And of course, for consultations, I usually say to Parliament that I like associations because they can afford to have experts, that they already amalgamate interests of various members. But the reality is, if you ask an SME, they will usually just stare at you blankly and say, this is really, we don't have time and money to invest in trying to understand a 1,200 page agreement when we sell 5 bicycles to France. That's not what we do. So at that point, you really need to have a more collective interest in mind and make sure that in those consultation processes, you somehow get at them, even though you can't ask them yourselves. By the way, another really interesting UK problem at the beginning of this whole process, all of the associations were European. There was no UK-focused trade interest because, of course, everything happened at the European level. So they needed to get the UK bits out of the already running associations. All tremendously fascinating and giving us work for decades to come.
Yes. Gabriel, on the US side, I can see Idona's got a question on this as well, on just the sort of the input to the, she's asking there on the, do you have a feel of whether the submissions were mostly those who had protectionist interests, or were they the liberalization seeking interests? So who was it? And then perhaps this question of just the complexity and the expertise. So again, yes, that bias, who's sort of giving input, and what are your reflections on those two?
Yeah, maybe I start with the last one to follow up with the Holger, and then I take the first question. So, in terms of balancing the complexity with the capability of stakeholders to produce meaningful input, I would say, first of all, the stakeholders know very well what are their needs, right? yesterday we had an event on the UK-Australia trade agreement, and we had an architect talking about the problems. It was not within the UK, but they said, well, I export architectural services all over the world, and in France there is a specific issue on insurance that has this and this. So they know very well what do they need and what they don't. In terms of rules of origin, that the legal implementation can be a massively complex legal document. That you are using some inputs from foreign providers that you may no longer be able to do that, and that will have implications. So I would differentiate between what are the actual needs with the legal implementation of those requests. And this brings me to the second issue, which is the timing of the consultation, right? At what point do you throw to stakeholders a almost fully completed agreement with all the documentations, or there is an ongoing process which you engage with civil society, you engage with the industry on see where are they, what are their needs in implementing. So this last minute thing is what makes things more complex. So having advisory committees, having ongoing consultation process, I think are very important. And in terms of the requests that we found in the consultation exercise, whether they were mainly pro-liberalization or protectionist, you find examples of everything. For example, in sugar, you have those who want to protect the sugar as much as possible, and confectionery industry who want cheaper sugar, and they say, no, let's liberalize this and let's buy the sugar. The rules of origin as well. On textiles in particular, those who say, no, we have to have very strong regional value content, and others, the fashion industry and others more integrated in global value chains, say, no, we need more flexibility into this. So again, for me, what is important is to infuse the process of transparency. So to show, okay, this is what people are asking for. Maybe how is the negotiator balancing these interests, and perhaps also conducting objective impact studies, and release those impact studies to the stakeholders as well, to somehow have a more impartial view from a technical perspective.
Really interesting points there. Yeah, please, Holger, come back in.
Oh, it's too. I'm interfering with my command bar there. Okay, I was wondering, Gabriel, because you do have these objective, if objective they can be called, these stakeholder engagement processes, which give you the semblance of depoliticization, where you say, well, now the negotiator has the input of the various industries, and now he just needs a formula by which he says, well, this industry was shouting a good lot, but actually it's really tiny, so forget about them, and this industry is really important. Where does the politics of it come in? Meaning, for example, let's assume you vote into government, a green government. Not going to happen in the UK, of course, but let's say the EU. They're voted along the platform of advancing environmental interests. So if the chemical industry, the car industry, all shout a good lot, isn't the outcome of the elections already a sign of prioritization by the voter, which might not reflect objective, if those even exist, industrial interests, but actually say, you know what, besides the industrial interests, this is another interest, and right now that's more important for us. And how do you balance those two things?
Thank you very much, Holger. And the question is, I don't know. It's an excellent question, but I don't have the answer. But let me tell you some things that I found in the research, why I said that the dice had been cast before the consultation. And that is because, the Trump administration came into office with a clearly defined trade policy agenda. They wanted to reduce the trade deficit. They wanted to protect manufacturing sector, and there are specific trade rules to advance those objectives. And one of the things reading in these hearings where Lighthizer goes to Congress to explain the trade policy agenda, he was pressed by Congress people there. Well, some stakeholders say this about the rules of origin. This was at the time that he was making the case for renegotiating NAFTA rules of origin. And how are you sure that stakeholders really want what you're saying? And he candidly asked, I have no idea what companies want about rules of origin. There are so many companies. So clearly said, we won, and we won on this agenda. We're going to push for that. So I think it's very important. I'm not advocating for a technocratic depoliticization of the entire process. But I mean, there is a balance. Elections are once every 4 or 5 years, and on the very general level, you don't decide exactly the nitty-gritty of the trade policy. So there is still a need for engaging with stakeholders, but I'm well aware that there is a need of this balance between political mandate and day-to-day stakeholder input.
Can I introduce a little bit of a different slant of politics in? Because I think, so Holger's brought the kind of party politics and the political manifestos, and that's an important consideration. I guess the other concern from a political science point of view is that big industry sort of captures the process, right? So you've got big industry like the pharmaceutical industry or the big tech industry that have the sort of partly the capacity and the information so that they can actually say, we understand all the technicalities and they can put in proposals, but also their sheer economic weight, the fact that they might be very important in a particular senator or a particular congressional representative's district. So therefore, we've seen on the TPP negotiations back in the day, actually on pharmaceuticals and biologics, it was one senator's interests and he had a deciding sort of casting vote on it. And actually that really held up the negotiation. So just that type of politics, I'd be really interested to think about when politics, if you like, some actors have undue influence, and where does that arise, and what might we do about that? So I'd be interested if any of you have thoughts on that. Please, Elisa.
This is very important, and of course it's very true. And I underscored the approach of the European Commission with reference to small and medium enterprises. If we read the 2021 EU trade policy review, the document that was issued in mid-February this year, there is a part that is devoted to small and medium enterprises, highlighting the need and so the purpose of the European Commission to promote tools in order to allow small and medium enterprises to participate in a more meaningful way to this shaping of the EU trade policy, to this governance of the global economy. So the asymmetric situation is very well perceived, and at EU level, the EU institutions move in order to give a greater voice to these subjects who are, I am not an economist, but the small and medium enterprises have the highest percentage in the economic output of the EU. So basically, the issue is always the same, to open and to be transparent, because transparency is a compulsory precondition for having
Elisa,
democracy.
can I just push you on this, and I'm sure others want to come in on the question of politics and capture, but on the transparency, you've mentioned transparency a lot, and when certainly in my engagements with negotiators, that's the last thing they want is full transparency, because they precisely want to get a maneuver inside the negotiating room and argue that actually, look, full transparency is going to make my job really hard in the negotiating room, where I might need to make trade-offs that one particular branch of industry might not be happy about, but in my judgment as the sort of the civil servant that's leading the negotiations, I need to have that autonomy and that room for that. So actually fully transparent trade negotiations creates problems. So where do we draw the line? Well, A, do you think there's credence in that argument? And B, if there is, where do we draw the line between sort of what needs to be transparent and publicly accessible, and actually what should be behind closed doors to enable the negotiators to create interesting packages and therefore further the sort of the national interest? Yeah, perhaps you, and then we'll go to Holger and Gabriel on that question.
Thank you for the interesting question. In order to answer, I go a step back, and I wanted to highlight very clearly that in my view, currently, we are undergoing a true revolutionary cultural change. And this true revolutionary cultural change is that international economic law, since it is decided at international level, has to be transparent. So the fight that we used to fight and to have for more transparency at national level, now they are transposed at international level because of the rhythm, the very quick rhythm of globalization. You cannot stop globalization. Here everything is moving because we need new tools in order to provide the democracy in this globalization process, because you cannot stop it. If you step back and you say, okay, I don't want a globalization, it is possible to say I don't want a globalization because of the technological progress, because of the way in which we communicate, and so on and so forth. So I think, yeah, so, of course, I understand the reason of the companies, they have business and confidential information to protect, very well indeed. Then we observe rules for business and confidential information to protect. But these cannot be the presence of business interest cannot be an automatic limit to transparency. We have to go in depth and to make a distinction between what is a business confidential information and what is an interest that is to be considered together with the other in a transparent, open and accountable debate. And
brilliant, thank you, Elisa.
It's a new frontier that we have today.
Great, so things are shifting. I'm hearing things are shifting. We're in a new time. Everything needs to be fully transparent. Even, and this question is going to Holger, even sort of then the negotiating texts, consolidated negotiating texts in draft form that are sort of live documents in the room. Again, does this, where do you sort of, what are your thoughts on this transparency question?
Yeah, I think it's a really, really difficult one, because the first thing is, I entirely agree with you. You hear from a lot of negotiators, if we do that, we're not going to get to an agreement because we will lock ourselves in the moment we publish, because at that moment, moving away from the text will be really, really difficult and will be perceived as you gave in. And that is a compelling narrative. Of course, you could rephrase and reformulate the whole narrative, and you could say, who's actually the person entitled to make the trade-off between Industry 1 and Industry 2? Who has the legitimacy to say, you know what, we really have to screw agriculture because car manufacturing is more important? Is it the technocratic trade negotiator who can do that to get the deal over the line? Or is that, in constant consultation with the public, the politician who at one point makes the call and has to transparently, in an ideal world, has to transparently say, you know what, I feel your pain, but the win is worth the loss. So, and in an ideal world, of course, you'd say full transparency, disclose everything, constant consultation, stay in touch with the people, inform them. We know that the real world is unfortunately not ideal. And there we get to a lot of hypocrisies. In fact, one more hypocrisy also for Gabriel. Yes, the negotiators, there's a lot of consultations. But also, Congress has already put out the trade objectives in fast-track legislation to some extent. And they're not going to be reformulated because of the consultations. But the next thing is that a lot of trade negotiators will tell you, you know what, we've done these consultations 500 times before, and I speak to them every week anyway. So yes, now I get a formalized document which says everything that I've heard 300 times over. I'm so bored, I'm not going to bother. I know what they're saying. So the reality is this is a close-knit community in which Big Pharma is going to write a long document in a consultation process saying, we want more patents. And not anyone in the world is going to be surprised that that's what they're saying, because they've been saying it for so long. The question is, how do we maneuver around these various hypocrisies and I think for me, the real solution is constant engagement. When the trade-off comes, the sector that is going to be traded off should, in the back of their mind, already know when push comes to shove, we've yelled a good deal, but we're not as important for the economy as the other sector. And yes, they're going to try to yell and get their interest through nonetheless. But I hope that can achieve something. But then, of course, as an academic, we're all idealists, and it might not help. And in the end, secrecy is what gets you over the line and is better for the public good, because otherwise you'll have a whole lot of yelling and the loudest voice prevails. Unfortunately, secrecy doesn't guarantee that the fair voice prevails either. In secrecy, it's usually the most influential voice that prevails. And whether it's trade negotiations or legislation, if your MP is the Prime Minister, your constituency has a louder voice than the neighboring constituency, even though they might be more important.
So, Gabriel, two questions on the table then for you. One on this sort of the question of transparency, and the other on this question of sort of the role of these different stakeholders and the sort of the informal behind the scenes. So are you capturing everything as sort of as I'm sort of hearing Holger? Because in a way, if the trade negotiators are talking to industry all the time, does the formal process really matter, and does it tell us much?
Look, I mean, all these are fascinating questions, but perhaps I would shift the angle of how looking at this, going to the political economy of sectoral interests, not that much as who decides, but how is the decision taken? How is the balance done? I think that's where we need to understand a little bit more. And I came across some examples. I mentioned rules of origin. Another one, which is very interesting, is the intermediary liability framework for internet service providers, where you have all these massive big tech companies that want a light approach to say, well, whatever happened in the web, it's not my responsibility. Let's foster innovation and free flow of data. And then you have the creative industry, the news, the media, the recording industry. Look, you have to take responsibility for these issues. And you look at the submissions of big companies that are very detailed, over 20 pages analyzing this and all the evidence. So you can tell that there is a team there, and they are repeated in different consultations, so they have an active engagement. Others are less prepared, but my sense is that the game is not played in this consultation process. So it's something that takes longer. It comes from before. And that's where it would be interesting to shed a little bit more light on how these issues are handled. Yes, Holger is right that the trade policy, the trade authority, promotion authority sets negotiating objectives, but they set them at a very high level. I mean, if you look at on investment, for example, on ISDS, which has been a very topical issue, many argue that the push that the Trump administration gave to move so much away from that somehow was against the mandate of the trade policy, the way the objective was there. So there is some maneuvering as well, and there is more need to understanding the nitty-gritty. I think the way to look at this is to look at specific industries. It comes to me, I said intermediary liability, but maritime services. So the maritime sector in the US has traditionally been notorious for the protectionist approach. There are so many economic analyses that tell those who know that this is not good for the US economy, but still the US Maritime Coalition and others have managed to put that on exception and protection in one agreement after the other. So how this happens, not who takes the decision, how is this possible? We need further research on that.
And so much of it that happens behind closed doors, right? It happens within bureaucracies, and it's going to be quite hard to get a handle on as researchers. So our time is fast spent. I can see Kimani's just put a question in the chat. I was going to ask each of you just for sort of 1 or 2 sentence, just final reflection on this. It seems to me we've had a fascinating discussion. on just the reach of contemporary trade agreements. We're codifying so much in international law, they're often binding instruments, and yet the processes of legislative scrutiny as well as stakeholder engagement leave a lot to be desired. Also, there's clear gaps for us as researchers properly understanding these processes and thinking through from a kind of normative perspective what we'd like them to look like. So perhaps we just go in reverse order. We'll go Gabriel, Holger, and then Elisa. Very short intervention, just one thought that you'd like to share.
Yeah. Yes, one thought. I mean, we are gone are the days that trade policy was managing the interests of producers of like import domestic products and exporters. We need to update the institutional framework for trade policy making, revise what's the role of parliament. Something we did not speak is the coordination mechanism between different public authorities with competence over trade, the regulators, the ministries, and stakeholder engagement. It's a topic that has come to stay, and if we really want, these inclusive trade policies, we need to look back at how is the institutional engineering of this process.
Thanks, Holger.
I would say we need to integrate trade policy into overall policy and not create a separate outlet of policy making. And to Kimani, I think there are two answers to your question there. One is impact assessment, where you just accumulate GDP effect, which is very numerical. And the other one is politics, where you can very well say, you know what, don't care about GDP. Our agricultural sector takes care of the environment, takes care of the land, and we're going to give that preference, and that will be more important for us.
Thanks. And Elisa, you have a final thought.
Yes, with technological development and the very fast process of globalization, I think that we are entering definitely the era of knowledge. So preparation, knowledge, also of international economics, international treaties is essential in order to do business today, even at a small level, let's say so. So in this way, in order to promote in order to keep democracy and to strengthen democracy, I think that the first and not renounceable tool is transparency. And so we have to take this challenge and to develop the evolution of our domestic institutions towards the path of transparency. Definitely.
Thank you so much. And I think this has been a really interesting conversation, much appreciated. On behalf of everyone who's tuned in and has been listening, thank you all, the three of you, for really insightful thoughts and reflections.
Thank you.
Thank you so much, Emily. And thank you, Gabriel and Holger.